I'm not hearing anything else from you. I'm going to do what I'm going to do.
That's fine.
I'm just
That's
going to,
fine.
no, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
Before this hearing even officially begins, you can already feel the tension brewing in this courtroom. What you're about to watch isn't just a routine legal update. It's the continuation of a case that has clearly been dragging on for a long time, and both sides are starting to show signs of frustration. On one side, we have Mr. Stenford, who claims he has submitted evidence including a flash drive with video from a previous hearing that could influence the outcome of the case. On the other side is Miss Susie Norman, who appears convinced that key issues were already resolved in a prior court session. Now here's where things get interesting. According to Norman, during a previous hearing, Mr. Stenford supposedly waived his right to collect monetary damages and rent related to the dispute. If that claim is accurate, it could completely reshape the legal argument going forward. But Stenford has now filed additional responses and evidence that the court must review before any decisions can be made, and this is where the courtroom process becomes incredibly important. Judges are required to ensure fairness for both sides, which means every document and every piece of evidence must be shared with both parties before the judge can consider it. If even one side hasn't received a document, the judge can't legally move forward. So the real question here is this: is this simply a misunderstanding about missing paperwork, or is there something bigger going on beneath the surface of this? Dispute with us, because what starts as a discussion about evidence quickly turns into a tense exchange that pushes
Susie
the
Norman.
judge's patience to the limit.
Okay. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think
also,
we have it now.
Yes. And I believe that your coordinator helped Mr. Stenford to play his flash drive.
Right. Did you get all the stuff off of the flash drive?
I did see the video of the previous hearing on that, yes.
Okay. And so with reference to that previous hearing, you have something you're holding.
And just like that, the tension in the courtroom reaches its breaking point. The judge had initially tried to speed things up by emailing the submitted documents directly to Miss Norman, so that both sides could review the materials immediately. That approach could have allowed the hearing to continue without another delay. However, once the exchange between the judge and Miss Norman became confrontational, the judge decided to abandon that plan and return to the traditional process. Instead of emailing the documents, the judge chose to adjourn the case and wait for the materials to arrive by mail. This decision effectively postpones the proceedings and pushes the case to a new hearing date. March 10th. Important about courtroom behavior, respect and decorum matter. Judges control the pace and structure of the courtroom, and once they feel that line has been crossed, they have the authority to end discussions and move the case forward on their own terms. Now the big question moving forward is whether the evidence, especially that video from the previous hearing, will confirm Miss Norman's claim that financial damages were waived. If you found this courtroom moment as intense and revealing as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Something you're holding up. What are you trying to do?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15th, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say something?
How did you send this to Miss Norman?
U.S. mail.
Okay, well,
yeah,
that's going to be.
I thought our hearing was a little later in the month. I thought she was going to get it, and I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
Well, that maybe should tell you something about the mail. All right. Here's what I'm going to do. I think we have Miss Norman's email, right?
Yes, sir.
Okay. So, folks, they're not sure that. Yes,
Can I
ma'am.
say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point we're just on the court's time and we're wasting it with
Well,
all of these things.
Ms.
It's just-
Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least
At
look
this
at
point
it
in the
and
hearing, you can clearly feel the frustration building. Ms. Norman mentions that she has already appeared in court around 13 times for this case, which is a significant amount of time and emotional investment for anyone involved in a legal dispute. From her perspective, it sounds like the case should already be finished, especially if she believes a prior agreement resolved the financial claims. But from the judge's perspective, the situation looks very different. Judges have a legal responsibility to review every filing that comes before the court, even if one party believes the matter is already settled. The judge cannot ignore a document that has been officially submitted as part of the case record. This is where courtroom dynamics can become tense. One side wants closure immediately, while the judge is focused on following procedures step by step to avoid mistakes that could lead to appeals or legal challenges later. So here's a question for you watching this. If you had been in Ms. Norman's position after attending court more than a dozen times, would you still stay patient with the process? Or would you feel just as frustrated?
I
as she
have
does
to
here?
at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right, because I don't want to end up in this circumstance. We have Ms. Norman's email.
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I'd put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay?
So,
And then
so what
my
happens
next-
then? He's got an answer to the video, and then I see something on his answer, but yet I can't answer.
then you guys can argue that before me. Ms. Norman, I can't force this to go any different.
I don't
If
want
I
to
could-
argue. I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Ms. Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case.
Ms.
He has-
Norman, I'm
I'm
going to
just-
tell you this, and then I'm not hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just
That's
going to,
fine.
no, do not talk. Stop.
I said I won't
Just
say anything else.
stop. Just stop.
That's how you treated me in October of 2024
This moment
as
might
well.
seem like a small procedural detail, but it's actually a critical part of how courts operate. In legal proceedings, every piece of evidence must be shared with both parties before it can be considered by the judge. That includes documents, written responses, and even digital files like the flash drive mentioned here. If one side submits something and the other side hasn't received it, the judge cannot move forward fairly. What makes this situation interesting is the content of that flash drive. It apparently contains video from a previous hearing footage. That Miss Norman proves Mr. Stanfler waived his right to monetary damages and rent. If that claim holds up, it could dramatically weaken Stanford's position in this case. But the judge can't simply take someone's word for it. The court must verify the evidence, review it carefully, and make sure both parties have equal access to it. This is why cases sometimes feel slow or repetitive to viewers. The legal system prioritizes fairness and documentation over speed, even if that means
Me in
delaying a
October of
hearing.
2024 as well.
I'm done. Then here's what we're gonna do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep, we'll just put it out so she can get the mail. I'm gonna do it that way. I was trying to expedite it for her, but she's gonna treat me rudely. It's not gonna happen that way. Give me a date. I'm done. Mute her, because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
Thank you. See you then.
Yep.